Well, good morning, everyone, and welcome to the first in a series of webinars that I'm going to be hosting over the next few months, which will cover a variety of topics concerning contentious probate claims. My name is Ali Toe, and I'm one of the senior associates in the dispute resolution group here at Boyce Turner, and I will be hosting today's webinar. This is a live webinar, so please feel free to post any questions you may have as we go along through the question and answer panel. This webinar may raise a number of questions, so please bear with me. I will try and answer your questions at the end of the webinar, but for any of those that I'm unable to respond to, I will endeavour to get back to you separately. I may not be able to answer specific questions on air, as I may need to understand more about the context of the matter and the question. However, if you do need to talk to me about a specific matter, please contact me directly and I will come back to you separately. Although live, today's webinar is in listen-only mode. However, as I say, you can send us any question or comments through the Q&A panel, and I will do my best to answer as many of them as I can at the end of the webinar. So let's get started. Contentious probate claims cover a wide variety of topics, including lack of testamentary capacity and wanton knowledge of approval of wills, undue influence and forgery of wills, rectification of wills, lost wills and deathbed gifts, proprietory estoppel claims, Inheritance Act claims, and the removal of executors or administrators. Today I'm going to consider the first of these topics, namely lack of testamentary capacity and wanton knowledge of approval of wills. So firstly, testamentary capacity. It's a legal requirement that in order to make a valid will or to make any changes to an existing will, a testator, the person executing the will, must have the requisite capacity, what is known in the case of wills as testamentary capacity. The question of testamentary capacity first came before the courts back in the 1800s in the case of Banks v. Goodfellow in 1870. Banks set out a series of questions that should be asked of testators in order to test whether or not they had testamentary capacity. The common law test in Banks has stood the test of time and remains good law today. Banks established that in order for a testator to have testamentary capacity, they must understand the nature and effect of making a will. They must understand the extent of their property which is being disposed of. This does not need to be a complete pound, shilling and pence exercise, but a general overview of the assets held. They must understand and appreciate the claims to which effect ought to be given. So this would include any potential Inheritance Act claims. As I mentioned, we're going to be looking at Inheritance Act claims in another of our webinars later in the year. But briefly, this would include, for example, any spousal claims, claims by children of the deceased, or claims by those being maintained by the deceased at the date of his or her death, and in certain circumstances, any cohabitees of the deceased. And lastly, the testator must not suffer from any disorder or delusion of the mind capable of affecting their decision. This is particularly important where a client is elderly or vulnerable, or is known to be suffering from a mental illness such as dementia. However, just because a client does have dementia or is more senior in age, does not necessarily mean they will lack testamentary capacity. Where a testator does suffer from such illnesses, or indeed vulnerability, it's often good practice to ensure that the will is witnessed by a medical practitioner and/or medical advice obtained on the testator's state of mind at the time of execution of the will, and to ensure that any contemporaneous notes are taken of any examination and findings by the medical practitioner. This is only applicable to cases where a solicitor is instructed to prepare the will, and this has become known in practice as the golden rule. It should also be remembered that the question of testamentary capacity is assessed at the time of execution of the will. It is possible with some illnesses for testators to have capacity on one day, but not necessarily the next. This does not matter as long as they had capacity at the time that they executed the will. However, what happens if at the time of execution of the will, the testator did not have capacity, but did at the time of providing instructions? This scenario was considered in the case of Parker and Felgate in 1882, and it relaxed the Banks and Goodfellow test. In this case, the court found that if the testator had capacity at the time of giving instructions, and the will as prepared and executed reflected those instructions, then as long as the testator had sufficient understanding to understand the nature and effect of making a will, it did not matter if at the time of execution they did not remember giving instructions for the same. There remains considerable criticism within the industry of the effects of Parker and Felgate, but despite such criticism, the Law Commission has indicated it has no intention of abolishing the rule, and for the time being at least therefore, it remains good law. If the testator is found to lack testamentary capacity, then any prior will, provided the testator had testamentary capacity to make that will be proven, or if there's no prior will or the prior will is not valid, then the estate will be administered in accordance with the rules of intestacy. The burden of proof in relation to testamentary capacity claims is subject to the following rules. Whilst the burden of proof lies initially with the propounder, the person seeking to uphold the will, where the will is duly executed and appears rationale on its face, then the court will presume capacity. In such case, the evidential burden shifts to the person challenging the will to produce evidence in order to rebut this presumption. If a will doubt is raised, then the evidential burden shifts back to the propounder to establish capacity. However, recent case law has started to see a move away from court determination based on shifting presumptions, with the courts now tending to favour consideration of the evidence as a whole. The starting point for any claim alleging lack of testamentary capacity is the will itself. For example, was the will professionally prepared? Was it executed in the presence of the solicitor or at the testator's home? Is the testator's signature visibly shaky or unusual in any way? Are there any grammatical or spelling errors? The complexity of the will may also be a factor. A simple will is easier to understand than a complex one. Next, you should consider whether there's been any previous wills, and if so, compare them with the most recent one. Does the new will represent a significant departure from the previous one, or ones if there's been more than one previous will executed? What about the attesting witnesses? Their evidence as regards the execution of the will may be helpful. And what about other witnesses? Did the testator have any good friends or other persons, for example, carers, neighbours, gardeners or hairdressers, who would be able to provide evidence as regards their state of health at the time of execution of the will? If the will was professionally prepared, steps should be taken to obtain a copy of the solicitor's file and also obtain a statement from the will drafter himself as regards the preparation and execution of the will. In the case of Lark v. Nugas in 1999, the Court of Appeal confirmed that where there is a serious dispute surrounding the validity of the will, all circumstances relating to the preparation and execution of the will become relevant, and accordingly the will drafter should assist with any inquiries in this respect. The testator's medical records may well provide key evidence as to whether or not the testator lacked capacity. Under the Access to Health Records Act 1990, any person who may have a claim arising from an individual's death may apply to the record holder for disclosure of the testator's medical records. A review of the testator's medical records will also help in determining whether an expert report should be obtained on a retrospective basis as regards the question of capacity. It should also be remembered that a will executed whilst a testator lacks capacity does not become invalid by the testator's subsequent recovery. Remember, the question of capacity is considered at the time of execution of the will. Lastly, consideration should be given as to whether or not to register a caveat at the probate registry to prevent a grant of probate or letters of administration from being issued if this has not already happened. So what does all this mean in practice? Well, let's look at a couple of recent cases. In Parsonage v Parsonage and others in 2019, one of Mrs. Parsonage's 4 children brought proceedings challenging the validity of her latest will in 2011 as regards lack of testamentary capacity and also want of knowledge and approval. For our purposes today, I'm just going to look at the challenge in respect of lack of testamentary capacity. The underlying factual basis of the challenge was the severity or extent of Mrs. Parsonage's dementia and the circumstances in which the will was prepared and executed. The will as prepared was very simple in nature and provided for the residual estate to be divided equally between all 4 children. The will was prepared by an experienced solicitor who took instructions for the same from Mrs. Parsonage over the telephone. Following the telephone call, a draft was sent to Mrs. Parsonage, reminding her of the terms of her current will and its rationale as he understood it from previous instructions. Mrs. Parsonage arranged to execute the will in the presence of 2 of her neighbours who also witnessed the same. One of her children was also present at the time. The 2011 will differed significantly from Mrs. Parsonage's previous will made the year before, which broadly speaking provided for specific gifts to each of the 4 children, with the residuary estate then being divided equally between just 2 of them. This will had been executed in the presence of the solicitor. The court found that Mrs. Parsonage had been considering the contents of her will over the Christmas period in 2010. She had reached the conclusion that her current will did not reflect her wishes because it did not provide for an equal distribution of her estate between her 4 children. No assessment of Mrs. Parsonage's capacity at the time of execution had been undertaken by the solicitor, as Mrs. Parsonage had not executed the will in his presence. He told the court he'd expected Mrs. Parsonage to attend at his offices to do so, at which point he would have considered the question of her capacity at that meeting. Although the solicitor had not had the opportunity to assess her mental capacity, he said he'd not had any concerns during his telephone conversation with her that would have alerted him to the fact that she may not have capacity. Both witnesses to the will confirmed that they recalled witnessing the document and that nothing unusual had occurred. Medical records provided the court with an insight into Mrs. Parsonage's deteriorating mental health, but of themselves did not provide the answer to the question as to the state of her health at the time she executed the will. However, the court concluded that at that time her dementia was still mild and that she was still capable of sound thought and decision making. Applying the 4-stage test in Banks v Goodfellow, the court considered the evidence as the process for the production of the 2011 will was sufficiently clear to find a confident decision as to testamentary capacity. In the court's judgment, the 2011 will was a true reflection of Mrs. Parsonage's free mind in relation to the disposition of her estate at death. Accordingly, the court found the will to be valid. And then in James and James in 2018, there was a claim for proprietory estoppel, a topic that we shall be covering in one of our later webinars in this series. But the claim also sought to challenge the validity of the will based on an allegation of lack of testamentary capacity. The deceased owned a farming and haulage business. He and his wife had 3 children, 2 daughters and a son, Raymond, known as Sam. During his lifetime, he'd given away some of his land to one of his daughters, Karen, and had dissolved a farming partnership which involved transferring another piece of land and the haulage business to Sam. In 2010, he executed a new will, leaving the remaining land and residue of his estate to his wife and 2 daughters, but left nothing to Sam. Sam brought a claim to challenge the validity of the will. The court found that Mr. and Mrs. James saw a solicitor in May 2010 for the purposes of giving instructions to her to make new wills for both of them. The solicitor had not acted for Mr. and Mrs. James before, and her attendance note of the meeting made no mention of any consideration being given by her as to the question of capacity. Various discussions then took place regarding the contents of the wills before they were eventually executed. However, all these conversations were with Mrs. James and the solicitor, and not Mr. James and the solicitor. The conversations all centred on Mrs. James's wishes rather than the couple jointly, and once again there was no consideration of the question of capacity. Following these conversations, updated versions of the wills were prepared and both were executed by Mr. and Mrs. James. Expert opinion from 2 medical practitioners at the trial of this matter confirmed that at the time of execution of his will, Mr. James was suffering from Alzheimer's disease, resulting in moderate dementia. Applying the Golden Rule test, both experts considered that he had capacity to understand the nature and consequences of the Testamentary Act and sufficiently appreciated the nature of the estate which he was to dispose of. However, they disagreed over the question of whether he had capacity to appreciate the claims of his children on his inheritance. It was this third limb of the Golden Rule test that the court had to consider in more detail. In doing so, the court applied considerable weight to the drafting solicitor who confirmed in evidence that immediately before signing the will, Mr. James had appreciated that the balance needed to be redressed between their 3 children. The court considered that the will demonstrated a rational and balanced approach to the disposal of his estate, bearing in mind the transfers he had already made to Karen and Sam. Accordingly, the court found that Mr. James had capacity to appreciate the claims made by others on his estate and therefore had capacity to make the will. Sam's claim was dismissed and the 2010 will was entered into probate. So what about lack of knowledge and approval? Well, as I've already said, it's not essential for a testator to be able to give a pound, shilling and pence description of the assets which will form part of their estate. However, they must have a basic understanding of the same. As a result, these claims are finding increasing popularity with applicants. Applicants often feel that they may not succeed with a claim for lack of testamentary capacity and see a testator's inability to be able to understand the extent of their estate as giving them an opportunity to bring a claim in circumstances when they might otherwise have not been able to do so. It's often the case that claims alleging lack of want of knowledge and approval are pleaded together with claims alleging lack of testamentary capacity. In order for a will to be valid, as well as complying with the specific requirements of the Wills Act 1837 as regards signature and execution, the testator must not only have capacity to make a will, but also know and approve of its contents. Therefore, even if a testator may be found to have testamentary capacity, it may still be the case that they did not know or approve of the document they signed. When considering claims of this nature, the court must consider whether the circumstances of the offending will arouses the suspicion of the court as to whether its contents represent the wishes and intentions of the deceased, and whether scrutiny of the will by the court has dispelled those suspicions. If a will has been correctly executed and prepared by a solicitor and reviewed with the testator, then this will give rise to a presumption of knowledge and approval. It will therefore be for the objector to satisfy the court that the contents of the will are such that it arouses the court's suspicion. There is no judicial guidance on what may amount to suspicious circumstances, but recent authorities indicate that the following may be considered suspicious. Instructions that come initially from a person other than the testator, even if that person does not stand to benefit from the will. The will is prepared by a person who will benefit under the will or that person's legal advisor. The testator is deaf and dumb or blind. The deceased had no opportunity to read the will or have it read over to them before signing it. The will differs significantly from previous wills, particularly if any changes cannot be explained by changes in the testator's lifestyle. The will contains expressions or dispositions that are out of character. If capacity is not an issue, the testator suffered from a physical or mental impairment. burden of proof in relation to lack of knowledge and want of approval claims lies in every case upon the party propounding a will. However, as indicated earlier, there is a presumption of validity if the will was prepared by a solicitor and read over to the testator by that solicitor before execution thereof. As a matter of good practice, will drafters should adopt the following procedures. Read the will over to the testator and contemporaneously note these details. Record any conversations the testator had with witnesses as to their intentions. Retain letters from the testator in respect of their intentions. Note comprehensively details of the execution of the will. Note any matters of concern leading up to the execution of the will and any thereafter. And note any background reasons for the testator's dispositions, such as a falling out with a particular relative. More recently, there's also been some suggestion that practitioners should consider recording their interviews with the testator. In light of the COVID-19 pandemic, I would anticipate that video recordings by solicitors when taking instructions for a will, and also by testators when executing a will, are likely to become more common. This may well be a practice that moving forward, we will find will be considered the norm. And so let's look at a couple of recent cases on the question of lack of knowledge and want of approval. The leading case involving such claims is the recent case of Hawes v. Burgess in 2013. Mrs. Burgess had 3 children. Not long before her death, she'd made a new will, leaving her estate to her 2 daughters, but without any provision for her son. Under her previous will, her estate had been divided equally between all 3 children. The court heard evidence that Julia, one of Mrs. Burgess's daughters, had been a controlling force as regards instructions for the execution of the new will, which had been made without any knowledge or reference to the other 2 children. It was Julia who had made the initial appointment with the solicitors to have the new will prepared, and she was in attendance when the contents of the new will were discussed with her mother. She was also present at a further meeting when the contents of the will were read over to her mother by the solicitor, following which she executed the new will. Mrs. Burgess did not tell her son, Peter, about the new will, even though she told him about some cash gifts, which she'd made at about the same time to her daughters. He asserted that the contents of the will were such as to excite the court's suspicion, and he brought a claim seeking to challenge the validity of the will on the grounds of both lack of testamentary capacity and lack of want of knowledge and approval, although in the end the court did not need to consider the question of capacity. The court confirmed that whilst there is a strong presumption of validity of a will, particularly whereas was the case here, it's executed at the offices of an experienced and independent solicitor after he had read out and explained the contents of it to the testator. That presumption can be rebutted. The court concluded that Mrs. Burgess had retained a very close and loving relationship with all 3 of her children during her lifetime, and there was no obvious reason why she should choose to change her will. The court agreed that the will's contents were such as to excite suspicion on the court's part, and having reviewed the evidence, the court was not satisfied that these suspicions had been dispelled. Accordingly, the court found that Mrs. Burgess had lacked want of knowledge and approval as regards the new will and upheld Peter's claim. In the circumstances, her previous will, providing for a distribution of her estate equally between all 3 children, was entered into probate. And then in Ria v. Ria in 2019, Mrs. Ria died on the 26th of July 2016. Her daughter brought a claim seeking to establish that the will her mother made in December 2015 was valid and should be entered into probate. Her brothers, however, defended the claim on the basis that Mrs. Ria did not know and approve of the contents of the will, as well as other grounds which are not relevant in relation to the question of want of knowledge and approval. They sought to enter into a probate an earlier will executed by Mrs. Ria in May 1986. The 1986 will appointed one of Mrs. Rhea's sons, Remo, as executor and divided her estate equally between all the children. The 2015 will appointed the claimant, Mrs. Rhea's daughter, Rita, as joint executor along with a family friend. Under this will, Mrs. Rhea left her house to Rita. The house was effectively the only asset in the estate and was worth about £750,000. Rita had been living with Mrs. Rhea for some time by the time of her death, and during that period had provided, almost single-handedly, daily care to her mother, following a decline in her health after she suffered a heart attack in 2009. The court heard evidence from Mrs. Sukil, the solicitor instructed by Mrs. Rhea to prepare the 2015 will. Although Rita was present when instructions for the will were taken, Mrs. Sukil had made it clear to Mrs. Rhea that she preferred to see her alone, and Rita had only been allowed to remain in the room at her insistence. She told the court she was confident Mrs. Rhea understood her and that she understood Mrs. Rhea. Mrs. Rhea was Italian. She had moved to the UK in the 1950s, but one area of dispute between the parties was Mrs. Rhea's ability to speak and understand English. Nonetheless, Mrs. Sukil was emphatic that Mrs. Rhea spoke English sufficiently well to communicate her wishes and instructions clearly and coherently. Mrs. Sukil questioned Mrs. Rhea regarding her previous will and why she wanted to change it, and she said Mrs. Rhea told her she wanted to leave the house to Rita so that she had a home and because she took sole care of her. When asked if she wanted her son to inherit a share in the house, Mrs. Sukil told the court that Mrs. Rhea said she did not because they had abandoned her. These instructions were recorded by Mrs. Sukil in a written attendance note, and which she also arranged for Mrs. Rhea to sign. Following that meeting, Mrs. Sukil saw Mrs. Rhea again for the purposes of reading over the contents of the will, which she had now prepared for her. Mrs. Rhea's GP was present at this meeting in order that he could be a witness to the will. Rita was not present on this occasion. Mrs. Rhea's instructions as to why she wanted to leave the house to Rita was also confirmed by her GP, who also attended to give evidence and had seen Mrs. Rhea for the purposes of providing evidence that she had the requisite testamentary capacity to make the will. Despite a central theme running through the sons' evidence that their mother was a simple person with almost no ability to use the English language and without a mind of her own, the court considered the evidence of Mrs. Sukil and the GP painted a very different picture, and that she had clear views of her own and could be strong-willed and determined. The court also considered that whilst English was not her mother tongue, she could speak it to a moderate standard and was well capable of communicating her wishes and understanding what was said to her in English, if said in simple, straightforward language and not too fast. The court considered the evidence of the GP and Mrs. Sukil to be truthful and compelling, and demonstrated clearly and beyond any reasonable doubt that Mrs. Rhea knew and understood the effect and implications of the 2015 will, and that its terms represented her genuine testamentary intentions. The court stated it was in no doubt that Rita had discharged the burden of establishing that Mrs. Rhea knew and approved of the contents of the 2015 will. Accordingly, the 2015 will was entered into probate and the son's counterclaim was dismissed. So this concludes this webinar on lack of testamentary capacity and lack of wanted knowledge and approval. Does anyone have any questions? So we've got a couple of questions. First of all, I'm being asked, what about the test in the Mental Capacity Act 2005? Does that not have an effect on the Banks and Goodfellow test? Well, there was actually some doubt when the Act was first introduced as to which test would apply. But following the James case that I mentioned earlier, it has now become clear that the Banks and Goodfellow test remains the correct test for assessing capacity when it comes to the question of wills. So it's now quite clear, Banks and Goodfellow remains good law and is the appropriate test. And then I'm also asked, what if a solicitor had not followed the golden rule? Does that automatically mean the will is invalid? Well, no, it doesn't. The rule is a guideline for best practice only, and does not give rise to any formal presumption one way or the other. So I don't seem to have any more questions. So it just remains for me to say thank you for listening, and to say I look forward to welcoming you to our next webinar, which is scheduled for the 18th of June, when I will be considering the question of undue influence and forgery. So look out for more details about how to register for that shortly. In the meantime, once again, many thanks for listening. Thank you and good morning.